Hello again, this is Jim Maroney. In these sessions I want to explain to you what I'm calling competing interests. If I don't, or if someone doesn't explain these concepts to you, you're going to go through your bankruptcy and you're going to be very confused at times. You're going to wonder why people are asking you certain questions. You're going to wonder why you're having to come up with certain documents. So let's go through these, and after you complete these this series, Competing Interests, you're going to understand exactly what's going on in your bankruptcy. At the very top, if you'll notice, I have trustee represents unsecured creditors. In the Western District of Missouri, we have the Department of Justice, of course, and within the Department of Justice there's the U.S. Trustee's Office. So if you are filing a Chapter 13, the standing trustee, his name is Richard Fink, he and his staff will be the trustee for your Chapter 13 case. If you're filing Chapter 7, it works very differently. The U.S. Trustee's Office will hire an independent contractor. He's an attorney or a non-attorney that's been appointed to serve as a trustee. That trustee will represent your unsecured creditors. So very quickly, let's review again who is a secured creditor. Well, if your lender has a mortgage on your home, he's a secured creditor. The trustee's not going to represent him. He could care less. If you have an auto lender, that's a secured loan. The trustee doesn't represent the secured lender on your auto loan. The trustee represents people like your credit card debts, or any other debt that has no security. When you borrowed money on your credit card, you didn't promise collateral of any type to the credit card company. That's an unsecured debt. So the trustee is going to go through and through your bankruptcy, he'll be representing your unsecured creditors. Now let's take a look at the first one there where I have the arrow. Understandably, when you file your bankruptcy petition, you're going to be very interested in stopping an imminent foreclosure, stopping bank account attachments or garnishments on your wages. All of that's done. That's done through a section in the Bankruptcy Code called 11 U.S.C. 362. And I have videos on that for clients, and I fully explain the automatic stay. It's like an injunction that stops all creditor collection activity. But in addition to that, let's take a look at where I have the arrow. Debtor versus creditors who have judicial lien on debtor's residence. Let's assume that before you filed your bankruptcy petition, you had a credit card lender. He sued you, took you to court, and obtained a judgment. Well, here in Missouri, we've got two levels of courts. We have circuit courts, we have associate circuit courts. If a judgment was handed down against you in circuit court, that judgment became final 30 days after it was handed down. So if the 30 days have come and gone after the date of judgment, and then you filed bankruptcy, that credit card company has the equivalent of a mortgage on your residence. In like manner, let's assume it was an associate circuit court case. Well, if a copy of the associate judgment was filed in the records of the circuit court and sat there for 30 days, then it's a final judgment. It's a mortgage on your residence. Well, in bankruptcy, debtors benefit tremendously by this rule. If you have $15,000 or less of equity in your home, or if you have no equity, you don't have to have any equity, but $15,000 or less of equity, including zero, you and I can file a motion with the bankruptcy court asking that that mortgage, that judicial lien, be canceled. And we're going to prevail on that. So that's a competing interest in bankruptcy that you and I are going to want to follow through, so that after your bankruptcy is closed, we've prevailed on that motion. Then if and when you sell your house, you're not going to owe anything to that credit card company. That's called a motion for avoidance of judicial lien. It's a real valuable benefit to a debtor. Now, I didn't put it on the chart here, but there's one that's real close. Let's assume that you went into a finance company to borrow some money. Maybe your transmission needed to work on it on an emergency basis, or you had some other need for money. And the finance company said, yeah, we'll lend you the money, but you're going to pledge as collateral your television and your bedroom set. If you don't pay it, we're going to pick up your TV, we're going to pick up your bedroom set. Well, in bankruptcy, we have a list of personal property items, and if they were pledged as collateral for that type of loan, we again can file a motion with the bankruptcy court, and we can get that security interest canceled. The lender just becomes an unsecured creditor, and his claim to your TV or to your bedroom set is canceled. That again is a motion for avoidance of lien. So it's a real important benefit if you're in that circumstance. Let's take the next one. Debtor versus those who have secured debt that can be reduced in amount. I want to bring this alive to you, so let me give you some examples. Let's say that you have a car and you owe a lot more on that car than it's worth. We all call it upside down loans. If you've owned that car for more than 910 days, then in bankruptcy we can do one thing called redemption. We can file a motion with the bankruptcy court and say, okay, we're going to pay that lender off in cash, and we're going to pay him what the car's worth, and we want the debt canceled on the car. Well, that's called a redemption. Well, you're going to have to come up with the cash to pay off the value of the car. Well, there are kind of like three different ways that people frequently come up with that cash. One, on an upside down loan, you may be in a position of saving thousands of dollars. So you might go to your friends and relatives and say, hey, can I borrow this money and pay those guys off? I'm saving a lot of money. That's one way. The second way is you might go to your pension plan and withdraw the money from your pension plan to redeem the vehicle for what for its value. You're going to pay a tax on pulling money out of your pension plan. So you and I are going to have to compute, well, how much of a tax burden am I going to incur by pulling that money out of my pension plan versus how much money am I saving by redeeming the car. A third way, and a lot of people do this, if you've got a history of making timely auto payments, you can go to a number of companies that specialize in giving redemption loans. Now, they're going to charge you a couple points extra than what would otherwise be charged, but if you're saving thousands of dollars, it's still a good deal. So those are three ways where you might come up with the cash to make a redemption loan. Now, CRAMDOWN, what we call CRAMDOWN. Let's take that same upside down car loan, and you don't have the cash to pay off the loan. And maybe when you first came to see me, you were intending to file a Chapter 7. Well, one alternative would be to file Chapter 13, where you make payments into the court. But when you repay that car loan, if you've owned that car more than 910 days, you're only going to repay the value of the car rather than what's owed on it. And again, that offers you the possibility of thousands of dollars in savings. Another one that comes up is a mobile home. Let's say you own a mobile home, and you don't have to have owned it 910 days, but let's just assume that you have a mobile home and you do not own the land where it sits. You're renting a lot somewhere. Well, you can either redeem the mobile home for what it's worth, its value, or in a Chapter 13 plan, over a period of 3 or 5 years, you can repay the lender the value of the mobile home as opposed to what's owed on it. It's a tremendous benefit to a borrower. On these CRAMDOWNs, it's not up to the lender, by the way. You and I will make that decision. And if you want to hang on to it and save thousands of dollars, it's one hell of a benefit to you.